All right. Hello, everyone. How are you today? Let's see if we. Yes, everything looks like it's starting up. I'm going to make sure that the monitor is not unmuted. There we go. Good. Somebody yell at me if. Oh, yeah, here's float plane is up. Let's not do that. That'll start in the background. All right, we're good. Welcome, everybody. I'm Leonard French, your favorite copyright attorney, and this is not a copyright case, but it's up there with like internet law, Schadenfreude. Someone said today in a interview that this was Schadenfreude for attorneys. That this was just you can't drive past a car crash without looking. This is that for attorneys. This is a nightmare moment for attorneys, where all of us see we could end up in the same place and getting in trouble with a judge or a court case because something in our legal research tools or something in our understanding of technology fails in a way that we don't understand and causes us to embarrass ourselves at best or get in real trouble at worst. Remember the guy who accidentally made himself a cat on, it wasn't Zoom, but a court's Zoom-like call? That happened. Now we've got someone using ChatGPT as if it's a reliable legal research engine, as if it's an omniscient knower of all things that you can then just turn in as your legal brief, possibly without fully proofreading it. Now, I'll let the document speak for itself. What we have today is the hearing transcript that Judge Kevin Castel held on June 8th of 2023, just a few weeks ago. And thank you to the person, I forget whose name it was, posted this thing, because normally these transcripts cost a few $100. So having the transcript is only one part of it. I'm going to try and deliver the transcript to you by reading both parts or all the parts myself. I'm not going to do any funny voices or anything, but I will get dramatic when it's time. So without further ado, let's let the document speak for itself. This is in the United States District Court for the Southern District of New York. This is Mata versus Avianca, and this is the sanctions hearing over the fake ChatGPT cases. And the court begins the hearing. This is Mata against Avianca. Response on the order to show cause. Appearing for Peter Leduca, please. Catherine Foti from the firm Morvillo, Abramitz, Grand Eisen, and Anello for Peter Leduca. I'm sure she can say it a lot better than I can. And my associate, Penina Moisa. Good to see you, Ms. Foti. Appearing for Respondent Schwartz and the law firm of Levidow, and Oberman. And so Levidow, and Oberman is the law firm. Schwartz is the employee or lawyer that works for them, and so is the other person, Mr. Loduca. They are the sort of, not the defendants in the action, but the defendants in the hearing. They're the respondents in the hearing. Ronald Minkoff of Tyler Malsby, Ashley Alger, I see three attorneys? Ronald Minkoff, Tyler Malsby, Ashley Alger from the firm of Frankfurt, Kernet, Klein, and Sells. So there's a bunch of attorneys in the room. The court says, good to see you, Mr. Minkoff. Appearing for Avianca is Bart Bonino. We're going to skip ahead. The court continues. As I understand the submissions, and I want to make sure this is correct, it is not the desire of any of the three respondents, the respondents being the two individuals, Loduca, Schwartz, and the law firm, to affirmatively call any witnesses. However, they are making the individuals available for questioning by the court. Is that accurate? Yes, it is. So the court continues. At this point, I would ask Ms. Foti that you hand up the wet ink original of the affidavit. So they exchange some documents. They confirm Peter Leduca's full name. He is sworn in, and now the testimony begins. Judge, where are you admitted to practice? Mr. Loduca, I practice in New York at the firm of Levidow, and Oberman. Where are your bar admissions? The second department. I also practice before the first department. You're admitted to practice before this court. Yes. Are you admitted to practice anywhere else? The Eastern District, which they have reciprocity there. It's very nice. How long have you been practicing? Since 1989. You're experienced in litigation. Correct. He's had 37 years of practice experience, and he has handled thousands of cases. So we get to the meat and potatoes now. How do you do legal research? Not how does one do legal research, but how do you do legal research? Well, if I'm making a motion, I would look for prior examples to establish some template. Then I would start looking for cases to back up my argument. If I got the motion in, I would read the motion, and then I would review the cases and then see how it's applicable to the case. And if there's anything I can use in there in my opposition, then do my own research. Mr. Loduca, would you do this as book research in a library? Would you use Westlaw, Lexis? Please tell me. Well, recently I've been using Fastcase. It's something similar to like Westlaw or Lexis. It doesn't have all the bells and whistles that they do, but it's good for locating cases. Are you trained in Westlaw? Well, I was using Westlaw, but that goes way back to my law school days. When did you last use Westlaw? Probably 1980s. And Lexis, about the same time. Do you do research in libraries? I did originally, but now most of my research is done online. When did Fastcase come into existence? I'm not sure when it came into existence. I know it started about 15 years ago, maybe a little more. That still leaves us a gap in time when you stopped using Westlaw after law school. Yes. Then Fastcase came along. What did you start using in the interim between your ceasing to use Westlaw? Basically textbooks. Where did you do your research? Most of the time we had textbooks in the office. If I needed to go to a law library, I would do that. In Nassau, I would use the law library over there at the Nassau County Bar Association. So the judge is establishing that Mr. Loduca knows how to do his research. What did you understand your obligation to be, says the judge, when you signed the submission of March 1st, which was your affirmation in opposition to Avianca's motion to dismiss? This is the document with the allegedly fake cases. Well, I guess it's clearly fake cases now. My obligation was to submit the affirmation that makes arguments that were factual and truthful to the court and to represent my client. All right, you're an experienced practitioner. You're familiar with the requirements of the Federal Rules of Civil Procedure. Are you not? Correct. And you're familiar with Rule 11, are you not? Yes. And what did you understand your obligation under Rule 11 to be? That any affidavit or affirmation that is signed by myself would be truthful as to the contents therein. What about legal research? Did you have any obligation with regard to legal research under Rule 11? Legal research would be also the same. It would be accurate and truthful. How did you go about satisfying yourself that the research reflected in your affirmation was accurate and truthful, as you put it? He says, I relied on my colleague in my firm, Mr. Schwartz. Well, what do you mean by you relied on your colleague? What did you do specifically that constituted relying on your colleague? Mr. Schwartz is an attorney who has been at Levidow for longer than I had. He had this case at its inception when it was originally filed in state court. It was then removed to the federal district court, which is when you take things from state court and bring them to district court for some good reason. And at that time, it was felt that it would be best for Mr. Schwartz to continue working on the file. He was most familiar with it. So when it came time to respond to the motion by the defendant, Mr. Schwartz prepared the affirmation that did the research, as he was the most familiar with the case. I'm asking you now, though, you submitted your own affirmation under penalty of perjury. Is that right, Mr. Loduca, in the March 1st submission? I signed on the affirmation, yes. And what did you do, if anything, other than see that Mr. Schwartz had done work and signed your affirmation? What else, if anything, did you do, or is that all you did? Other than reading the affirmation, that is what I did. Well, what was your purpose in reading the affirmation? What were you looking for? I was basically looking for a flow, making sure that there was nothing untoward or no large grammatical errors. Did you read any of the cases cited in your affirmation? No. Did you do anything to ensure that those cases existed? No. Now, there came a time on or about March 15th that Avianca filed a reply memorandum in this action. Do you remember that? Yes. And it was short, 5 pages in length, correct? I believe so. What was your reaction when you read that memorandum? I did not read that memorandum. You're the attorney of record, correct? That's correct. You have the responsibility to the court, Correct. And to the client, correct? Yes. And you had submitted an affirmation in opposition to the motion, correct? I submitted the affirmation, yes. Were you not curious to know what was said in the reply? I gave the reply. I referred it over to Mr. Schwartz. I felt at the time he had responded to their motion. The reply came in. I knew that there was no further response, normally in that case, and I felt Mr. Schwartz was the most capable, if anything needed to be done with the respect. If anything needed to be done with respect to the reply affirmation at all, that he would take care of it. Inform me. Let me know. Okay, all right, says the court. Now, since you have read the reply affirmation, correct? Yes. And you know that it says very plainly, although plaintiff ostensibly cites to a variety of cases in opposition to this motion, the undersigned has been unable to locate most of the case law cited in plaintiff's affirmation, and the few cases under which the undersigned has been able to locate do not stand for the propositions for which they are cited. It goes on very specifically to refer to Varghese, for example, in quotation marks, because it disputes that there is such a case. It specifically notes that Varghese quotes Zickerman versus Korean Airlines, and there is no such case at that citation. But there is a Supreme Court case, not an 11th Circuit case, that arises out of the Southern District, and it has nothing to do with the limitations period under the Warsaw Convention or the Montreal Convention. You've seen this. I became aware of this after the judge's order to show cause, which, by the way, was, I think, later in April, end of April or something. And also footnote 1, says the judge. Did you look at footnote 1 and see again where they say plaintiffs cite Ehrlich versus American Airlines? They could not locate such a case, but there is a Second Circuit case by that name, which again has nothing to do with the issues here. Did you see that? Have you read that? I read that. When did you read all of this? I read this after your order to show cause of May 4th. At any time after the filing of this reply memorandum, did Mr. Schwartz approach you and say, "My goodness, they are saying these cases don't exist"? No, he did not. Did he alert you to any aspect of the defendant's reply memorandum? No, he did not. Did there come a time that you got an order from me dated April 11th and another one dated April 12th? Yes, Judge. And what did you do when you got those orders? When I saw those orders, I turned them over to Mr. Schwartz and I indicated to him the judge would like to see these cases. Did you have a discussion with him as to why the court would ask you to submit an affidavit? An affidavit annexing these cases. No, I didn't have a discussion with him at that time. Well, what did you do in response to my orders of April 12th and 11th, other than turn over this order to Mr. Schwartz? I didn't do anything other than turn over the order to Mr. Schwartz to locate the cases you had requested. Let me see whether I can refresh your recollection. Do you recall writing to me and telling me that you were going on vacation? Do you remember that? Yes. And you told me that you would be on vacation until April 18th. Do you remember that? Correct. And April 18th was the date I had ordered the submission to be filed, correct? Correct. And you asked me to extend that date to April 25th, correct? Yes. And I did? Yes. Would you agree that a fair reading of that was that you needed time when you got back from vacation to prepare your submission? I would agree. And that the delay was because you, Peter LaDuca, was going to be on vacation. Yes. Was that true? No, Judge. What did you do in terms of the review of the affidavit that you filed with me annexing the cases? How did you go about assuring yourself that your affidavit was true and correct? I read the affidavit, I saw the cases that were attached to it. Mr. Schwartz had assured me that this is what he could find with respect to the cases, and I submitted it to the court. Did you look at the cases that you were submitting to the court? I looked at them. You were aware that the court had ordered you to submit copies of the cases, is that right? Right. And you understood that with respect to what later turned out to be each of the 6 fake cases, the entirety of the case was not submitted. In no case was the entirety of the case submitted. Right, Mr. Schwartz had informed me that this is what he was able to download from the search online. So you understood that this was not in compliance with the court's order. I understood that this was the best Mr. Schwartz could find at the time based on the search that he or the database that he had available to him. The court. But you yourself knew that what you were submitting was not what the court had asked for. Correct, it was not in its entirety. So you took a look at the cases. Let's take a look. You have your affidavit there in front of you. I have it, Judge. Turn to the very first case, Varghese, and you see that the case is purportedly brought by Susan Varghese individually as the personal representative of the estate of George Scaria Varghese, deceased, right? Yes, Judge. And the first sentence of the opinion, it says it's an appeal from the dismissal of her, meaning Susan Varghese's, wrongful death claim against China South Airlines, correct? Yes. But in the second paragraph, it goes in an entirely different direction, and it says Anish Varghese, a resident of Florida, purchased a round-trip ticket, an airline ticket from China South Airlines, I'm skipping over things here, and she checked in Bangkok, or he checked in Bangkok for his flight to Guangzhou, but was denied boarding due to overbooking. China's Southern rebooked him on a later flight, which caused him to miss the connecting flight back to New York. As a result, Varghese was forced to purchase a new ticket to return home and incurred additional expenses. And it goes on to say that he is suing for breach of contract, breach of implied duty of fair dealing, and a violation of the Montreal Convention. Do you see that? Yes. What did you think when you read this? That's gibberish. It's a wrongful death claim by Susan Varghese. No, it's a claim by Anish Varghese because he was bumped from a flight and incurred additional expenses. Does that make any sense to you? Mr. Loduca, no, it doesn't. But I had no reason to doubt that this was an accurate reproduction of the case. It never dawned on me that this was a bogus case. Wouldn't that raise red flags as to it being a bogus case? Yes. No, it never crossed my mind, Judge. And when you got my order, you didn't think that to go back and say, maybe I should look at this reply brief that was filed by Avianca to figure out why the judge is asking these questions and why Mr. Schwartz is giving me a case that contains what to an experienced lawyer like yourself would appear to be gibberish? No, I did not, Judge. Now, with regard to this response, it appears to me to be in multiple fonts, typefaces, fonts. Do you agree with that? Take a look at your affidavit of April 25th. Yes, I'm looking at it, Judge. Does it appear to you to be in multiple fonts? Look at the listing of cases in paragraph 2. The cases seem to be outlined or highlighted as opposed to the rest of it, yes. That's true in paragraphs 2, 3, 4, and 5. The cases seem to be highlighted. Do they appear to be in a different font? The print might be a little larger. Well, how about typeface? Do they appear to be in a different typeface, one appearing to perhaps be Times New Roman and the other sans serif or some form? To me, it appears that it is basically, it's just larger. Who typed it? I believe Mr. Schwartz put this together. Now, how did you go about satisfying yourself that the things you were swearing to were truthful? I trusted the work done by Mr. Schwartz. Well, did you ask him any questions? Basically, yes. Were you able to locate the cases? And he told me, this is what I found. You had an actual conversation with him? Yes. How many days before the affidavit was shown to you? Before it was filed? Well, there is some, take a look at the notarization here. Right. The affidavit is dated April 25th, 2023, correct? And you agree that the notarization is from January of, the 25th day of January 2023, correct? Correct. So when did you sign this affidavit? April 25th, 2023. And when did you get a draft of it in advance of signing it? Either the same day or the day before. Did you have any conversations with Mr. Schwartz before you received that draft? Yes, to the effect that he needed to find the cases. That what? That he needed to find the cases. This is before, when the orders came in, right? Did you have a vacation at all at that time period? No, it was Mr. Schwartz that was away. But you said you were on vacation. Yes, Your Honor. And do you agree that the 6 cases that are referenced in the order to show cause are non-existent? Presently, yes, Judge. I think I have all the questions I needed answered by you. Thank you very much. If you want to make a statement, you're welcome to make one. Thank you, Judge. And Mr. Loduca makes a statement. Judge, first, The fact that my name went on a document that had falsehoods in it that was presented to the court just pains me to no end. I profusely apologize to the court and to the defendants just for that act alone, aside from any inconvenience or extra work I may have caused for them and yourself. At the time, I had no reason to doubt the veracity of the work done by Mr. Schwartz. I had worked with him in excess of 27 years. In that entire time, nothing even remotely close to this nature had happened. I had done nothing close to this nature. In hindsight, I should have been more skeptical. I apologize again, and I accept the responsibility that I submitted this affidavit. I can't go back to change what was done, obviously. What I can guarantee the court is that this will never happen again. Not only have we taken precautions to prevent this from happening, but I can personally guarantee you that I will never sign off on an affirmation that has not been thoroughly researched and every fact and every dot checked by me personally. If there ever came a time, and I would be resistant to it, that another attorney said, I need you to file this for me, they would have to wait until I looked at everything thoroughly myself, basically turn the case over to me before I ever do anything like this again. Thank you, Mr. LaDuca. So we're going to switch to Mr. Schwartz's testimony now, which is much more dramatic because he's the one doing this ChatGPT research and all that. But I thought let's take a break and maybe talk about Mr. LaDuca for a moment. So he's the attorney of record. He is licensed not only to practice law, so is Mr. Schwartz, but Mr. LaDuca has gone through an additional procedure to be admitted to the federal court system. Mr. Schwartz usually practices state law, so when they need to go into federal court, Mr. Schwartz doesn't automatically have the credentials to just start filing documents. He has to have the court's permission. And in the Southern District of New York, you need to be admitted in order to file things. There's no way to simply walk into court and start filing things as an attorney representing a party. Pro se party can do that, but not a representative. So Mr. Schwartz would have to go through this procedure of getting admitted and everything, and he probably qualifies for it, but why do that? It's $200 and a procedure, and Mr. LaDuca has the admission, so why not just file it under his name? Well, an attorney is an officer of the court, so if I file things in my name but you wrote them, I can get in trouble for what you wrote. And the court might not realize that there's a ghostwriter here, and there are prohibitions against ghostwriting as well. So I don't remember if Mr. Schwartz's name was on these things. I think it probably was. I don't see any accusations that it wasn't. But the filing party, or the filer, is Mr. LaDuca, which makes him responsible for what he's filing, because it's his butt on the line when you do that. So Mr. Schwartz, Stephen Schwartz, gets sworn in. He's admitted to practice in the Second Department of New York. He's been admitted since 1992, and he's primarily a personal injury, workers' comp, and disability law attorney, most of which are state law things. He's handled many cases, over 1,000. He's conducted lots of legal research, and we're going to skip a little bit of this. He explains how he does his legal research by, searching for issues and etc. Same kind of thing, using fast case, lowest law, which is more geared towards state law. He's been practicing for 30 years. Doesn't remember if he used other internet search tools. He hasn't used Westlaw and LexisNexis, which are the major but also most expensive search tools for legal research. He's aware that he can go to the law library for legal research. So the court's setting up the background. The guy knows how to do legal research. So how did you go about finding the cases that you cited in your memoranda? Mr. Schwartz says, first, I went to Fastcase, which is the research tool our office subscribes to. It did not have access to federal cases, so I began to attempt to try to find another source to find the cases. I tried Google. Again, I didn't have access to Westlaw or Lexis, and it occurred to me that I had heard about this new site, which I falsely assumed was like a super search engine called ChatGPT, and that's what I used. Well, what did ChatGPT produce for you, sir? First, I asked it questions about the topic that I was researching, in this case, the Montreal Convention and the issue of the statute of limitations, and then I asked it to provide case law, and it did. Case law under the Montreal Convention, or case law supporting the position you wanted it to take in opposition? Case law supporting the position I wanted to take in opposition, which was, how does the statute of limitations, or what is the statute of limitations according to the Montreal Convention, and then ultimately the issue of whether or not a bankruptcy tolls that statute of limitations. So you were not asking ChatGPT for an object, you were asking them to produce cases that support the proposition you wanted to argue. Right, first I asked it for an analysis, and then I asked it for the cases. What did it say when it gave you an analysis? Well, it told me what the Montreal Convention stood for. It told me that in many cases a bankruptcy can toll the statute of limitations, what the statute of limitations was. And then I asked it for case law to support its analysis, and that's what was given to me. Did it say to you that a bankruptcy stay can toll the statute of limitations under the Montreal Convention? Yes. Now I'm going to break in here for a second. What in the world is a bankruptcy stay tolling the statute of limitations under the Montreal Convention? Well, the simple version, I don't actually know the Montreal Convention, but the simple version is that when you declare bankruptcy in the US, basically saying you're insolvent and you can't pay your debts, there's a lot of legal requirements around it. You can't just Michael Scott it and shout, I declare bankruptcy. But when you do it, it kicks in the Section 362 stay, which is a stay of any collection attempts against your assets, your estate. When you declare bankruptcy, instead you sort of theoretically turn over your property to the trustee, and the trustee then has to evaluate your bankruptcy and all that. And while they're doing that, until the bankruptcy's over, creditors cannot come after you. The question here in this Mata v. Avianca case was, hey, this guy declared bankruptcy, but he also didn't file his case against the airline in time. Can he file his case against the airline late because he declared bankruptcy and that paused things for some period of time? That's the simplified version. What did it cite for that? You have your ChatGPT research. Show me what it cites for that. INRI crash over Southern Indian Ocean. Wait a minute, just get me to the page of your submission. Page 40, okay. That was in response to a query, not what's the law. You're the user here, right, on page 3? Yes. And the question you asked ChatGPT was, provide case law in support that statute of limitations is tolled by bankruptcy of defendant under the Montreal Convention. Correct. And they did that. Correct. But I asked you before, did you ever ask them the question, what is the law? Not provide me with a case. The computer complied. It provided you with a case. It wrote a case. It followed your command. Prior to that, I asked it to argue that the statute of limitations is tolled by the bankruptcy of the defendant pursuant to the Montreal Convention. What case did they cite to that? Didn't cite any cases. Now, there came a time that you were told that Varghese supported the proposition, correct? Correct. Did you read Varghese? I read the excerpts that were produced, yes. Are you accustomed to citing cases without reviewing the entirety of the text of the case? No. Then what caused your departure here? I just never could imagine that ChatGPT would produce fabricated cases, and my assumption was that I'm using a search engine that's searching sources that I don't have access to. And mistakenly, I take full responsibility for it. And looking back, obviously very extremely regretful that I didn't take those further steps. But due to the newness of the technology and my obvious inexperience in using the technology and my false assumptions as to what this website does, it just never occurred to me that it would be making up cases. I just assumed that it was not able to access the full opinions. But you just said to me you are not accustomed to citing cases without reviewing the entirety of the case, yet you did not have the entirety of the case, correct? Correct. Now you knew, and you told me this already, that you can obtain the full text of a circuit court case on the internet. Maybe it doesn't do great research, but if you have the citation to the case, you can pull up that case on the internet, correct? On Google, correct? Correct. Did you say, well, they gave me part of Varghese, let's look at the full Varghese decision? I did. And what did you do when you went to look up the full Varghese decision? I couldn't find it. And yet you cited it in the brief to me. I did, again, operating under the false assumption and disbelief that this website could produce completely fabricated cases. And if I knew that, I obviously would never have submitted those cases. I obviously should have taken further steps to go and find the Federal Reporter or go to more obviously Westlaw or Lexis to verify that these cases were accurate. In hindsight, God, I wish I did that, and I didn't do it. Again, I had no intent to deceive this court or the defendants. I was operating under a misconception and a disbelief that these cases could not be real, and that this website is obtaining those cases from some source I don't have access to. And I did not follow up, and I should have followed up even earlier, and I should have verified it. But, Mr. Schwartz, I think you are selling yourself too short. You tell me that you know that if you have a citation to a circuit court case, you can pull up that case on the internet, and you are not accustomed to citing partial cases, and it did occur to you. You told me to look to see the full, you looked to see the full case, and you looked for the full case on the free internet, and you could not find it. Is that accurate? Are we talking, yeah, a search engine such as Google or such? Yes. This was prior to filing the brief on March 15th. Yes, but I didn't deem Google. I thought that there are cases that I'm not going to be able to find on Google and that the cases could exist. I know that Google is not, there might be cases that are in legitimate search tools that are not going to be found on Google. But there are 6 cases that could not be found on Google, right? Now let me ask you the same thing I asked Mr. Loduca. You heard my questions. This non-existent case, Varghese, you concede it's a non-existent case, correct? Yes, obviously now. You didn't have much to go on. You had an excerpt from it, right? Right. And in the first 2 pages, principally the first page, you see it's written that Susan Varghese is suing for wrongful death of George Varghese in the first sentence, and then it goes on to say Anish Varghese, a gentleman who missed his connecting flight, was forced to purchase a new ticket, etc. This is something utterly unlike the wrongful death of George Varghese, right? Correct. Now we can agree that's legal gibberish. Looking at it now, yes, but at the time, if it was a partial excerpt, I maybe thought that the excerpt was taken from a different portion of the case. Okay, let's move on in the narrative here. So then March 15th arrives, you receive a copy of the reply from Avianca. What was your reaction when you read that reply that flat out said you cited non-existent cases? I don't think it said that they were non-existent. I think it said they could not locate them, operating under the false perception that this website could not possibly be fabricating cases on its own. I again just thought that I'm going to go back to the source, that I have a copy of those cases, and in the affidavit indicate that I couldn't find one and they are not full sites. Again, the words fake or false cases was not mentioned like they were false. I continued to be duped by ChatGPT, and again, it's embarrassing, putting it that way, but I wanted to be transparent to the court. The court asked me to provide the cases. We're not up to that yet. We are up to the March 15th at the moment. We are focusing on the March 15th submission and your reaction to it. Have you ever heard of or litigated against the firm of Condon and Forsyth? No. Have you ever heard of them before this case? No. Did you pick up the phone and call opposing counsel and offer to provide copies of the cases? I did not. What was your reaction when your adversary is putting the citations to your cases in quotations? The undersigned has not been able to locate this case referring to Varghese by caption or citation, nor any case bearing any resemblance to it. Plaintiff offers lengthy quotations from the, open quote, Varghese case, including that we have previously held, and this is the quote, that the automatic stay provision of the Bankruptcy Code may toll the statute of limitations under the Warsaw Convention, a precursor to the Montreal Convention. Avianca says their lawyers say the undersigned has not been able to locate the case. The quotation purports to cite Schiefring versus Korean Airlines, but that's an 11th Circuit case. No, it's a Supreme Court case, and that was 1996, and it was not about limitations period. What was your reaction to all of that? My reaction was ChatGPT is finding that case somewhere. Maybe it's unpublished. Maybe it was appealed. Maybe access is difficult to get. I just never thought it could be made up. So, just breaking in here, It sounds like Mr. Schwartz thought that ChatGPT really was like some kind of super search engine, like Google Plus. Well, oh wait, that was a thing that Google killed. Uh, but maybe he just in his mind, like, just really just this thing is awesome and just sort of bought it, like, just really just didn't think a second thought about it. It's sort of like highway hypnosis. We got a hit attorney search engine hypnosis going on here. I just never thought it could be made up. Maybe it's unpublished. Mr. Schwartz, don't sell yourself short here. You know what the symbol in a citation F3rd means, right? A number and then F.3D and then another number and the name of the court and the year, right? You know what this means? Yep, he says. What is your understanding of what it means for a case to have a citation of F.3D? The Siefring case in Varghese, what does it mean to you? 3rd Department, Federal District, 3rd Department. I probably didn't pay enough attention to the sites. Have you ever heard of a federal reporter? I have. That's a book, right? Right. And F3rd is the 3rd edition of the Federal Reporter, right? Right. And if something is in the Federal Reporter, then it, by definition, is not an unpublished case, correct? Right. So this gets a little bit into how things work for legal research. So the legal research engine is not the law and is not the cases. It's a copy of the cases, and it could be wrong. So if somebody's wrong, what do you go back to? What's the source? The Federal Reporter is where the cases are actually cataloged in book form by the federal government. So that's what they're talking about here. So you knew that these were not unpublished cases that you were citing, correct? Or at least Varghese and Siefring, right? So an unpublished case is like a not precedential case. It doesn't go in the Federal Reporter. Precedential cases, cases that stand for really anything precedential, they go in the Federal Reporter. How could you reasonably assume or think that maybe they were unpublished? You just told me that the citation would indicate to you that they were published. Due to my unfamiliarity with the federal court cases, it probably just did not occur to me. Again, it's just not entering my mind to suspect that the case is fabricated, so I'm not inspecting it under any kind of assumption that it's fabricated. The site looks legitimate. The judge said the judge that they named is a real 11th Circuit judge. Remember that for later. These are real judges. How did you know that? How did you know that at the time? I think I looked up the judge and saw at some point during this process, not at this point, but later. I'm asking you, before you filed, no, not at this point yet, or when you received this reply brief, I just was not thinking the case could be fabricated, so I was not looking at it from that point of view. This is a very short memo. It's a 5-page memo. They say plaintiff also cites to Ehrlich v. American Airlines 360 NJ Super 360, page 360, Appellate Division 2003. The undersigned could not locate this case, but knows that there is a Second Circuit case captioned Ehrlich v. American Airlines regarding the ability of a passenger to recover psychological damages following an incident in international transportation, and they gave the citation. What was your reaction when you read that? The same, Judge. Now, is it accurate, sir, that you were the person who was on vacation between April 11th and 12th of 2023 and April 18th when Mr. LaDuca's affidavit was due? Yes. When did you depart on vacation relative to April 12th? I believe April 18th. I don't have a calendar to remember. If I could see the days of the week, probably later that week after the 12th, so sometime later that week. And you returned on the 18th? Is that accurate? Yes. And what did you do? First of all, what was your research when you read the court's order of April 11th or 12th asking for copies of the decision in light of what you had read in the March 15th reply memo? What was your reaction to the orders? That I would go back to the source and I found the cases and I produced them for the court as best I could because that's where I got the cases. And again, still not imagining that they could be fabricated. Did you think the court issued that order without first checking itself to see whether the cases existed? No. That didn't cross your mind? You thought that the court just reads somebody's brief and they say, these cases don't exist, and the judge says, well, I guess I'll issue an order, 2 orders, not 1 order. I thought the court searched for the cases, could not find them, and I just wanted to comply with the court's order and produce the cases that I found. Sometimes it's easy to forget when you're just filing papers, especially filing papers electronically, that there's a person behind the other end of the thing and that's going to be reading this and scrutinizing you. What did you do at this point to assure yourself that the cases you were assembling were accurate, did exist, and the good judge and the lawyers at Condon and Forsyth were just incompetent at locating the Federal Circuit cases? I did not do enough, and I should have went to the federal reporters. I should have gone to the law library. There are many things I could have done to confirm the veracity of these cases, and I wish I had done it at that time. And I failed miserably in doing that, and I hate to keep saying the same thing, but it's the truth. And I'm being completely transparent with the court in that I could not comprehend that ChatGPT could fabricate cases. So I complied with the court order and went back to the only place that I could find the cases, which was ChatGPT. Let me ask you, did you do any other research in opposition to the motion to dismiss other than through ChatGPT, other than initially failing to go to Fastcase and failing there? Other than initially going to Fastcase and failing there? No. He did no other successful research other than ChatGPT. I'm sorry, Mr. Schwartz. I do feel for you. It's just so, it's thick Schadenfreude. You found nothing on Fastcase. Fastcase was insufficient as to being able to access, so no, they'll explain that later. Did you find anything on Fastcase? No. In your declaration in response to the order to show cause, didn't you tell me that you used ChatGPT to supplement your research? Yes. Well, what research was it supplementing? Well, I had gone to Fastcase and I was able to authenticate 2 of the cases through Fastcase that ChatGPT had given me. That was it. But ChatGPT was not supplementing your research. It was your research, right? Correct. It became my last resort, so I guess that's correct. Who typed the affidavit of April 25th? I believe that was me in conjunction with my paralegal. Is it in fact the case that there are multiple typefaces and fonts in this affidavit? It appears so, yes. And why was that? I think those were just copied and pasted from the source and put into a document. Tell me what happened with regard to the notarization of this affidavit. The affidavit, we often use old documents and just conform them that they are already saved in our Word program. So this was an older affidavit and we just changed the caption and the content and the notarization was changed, but mistakenly. We used this as a template and we just forgot to change the month. By the way, there's lots of problems with copying and pasting for lawyers because you can make mistakes if you copy paste something and forget to make the changes in the edits in a particular section. You might copy paste, a whole couple pages of something, have to change 20 things and forget and change 19 of them. And then, you're referring to somebody by the wrong name or somebody's account number is incorrect or something like that. So that really does happen, and it is a big deal to go through and catch all of those changes that need to be made. And so there really is a lot of opportunity in law firm IT to make sure these things don't happen. So the affidavit, we used it as a template and we forgot to change the month. Now, I received a submission just the other day on your behalf and it attached a draft of the affidavit. Can you get that in front of you? Take a look at the block in which it states sworn before me. Will you agree that the second line appears different than the executed affidavit? When I pulled it up afterwards, that's how it came up on my computer. So that probably it was in the other form. I don't know why the computer printed it like that. Did you correct it between the draft and the final? Because one has a plus H and the other one has a superscript TH? Yes, I must have, but the computer saved it like this. So you corrected the TH, but you didn't correct the month, January versus April. I corrected the year, which was originally 2011. I corrected the day, and I mistakenly forgot to have the month corrected. Tell me what happened. How did this affidavit come to be executed? The affidavit was presented to Mr. Loduca. By whom? By me. Where? In my office. Right, and he signed it in front of me, and I notarized it. Let me ask you this. You prepared the affidavit, and then what? Did you call him and ask him to come to your office? I probably went in person to his office. But you presented him with the affidavit in your office, though. Whose office did you present the affidavit in? His office. Where in his office in relation to yours? Where is his office? 20 feet away. You showed him the affidavit? Yes. Had you provided him with a draft prior to that? I don't believe so. What did Mr. Loduca say or do? He looked it over and he signed it. Is there anything else you wish to tell me? Says the judge. Mr. Schwartz then says, in conclusion, I would like to sincerely apologize to Your Honor, to this court, to my defendants, to my firm, to Mr. Corvino, to Mr. Loduca. I deeply regret my actions in this matter which inflicted a hearing today. I have suffered both professionally and personally due to the widespread publicity that this issue has generated. I am both embarrassed and humiliated and extremely remorseful. To say this has been a humbling experience would be an understatement. I have never been involved in anything like this previously in my 30-year career. I have never come close to being sanctioned or been threatened by sanctions in any court or tribunal. I greatly regret my actions and hope I can put this matter behind me. I can assure this court that nothing like this will ever happen again. I have already taken a CLE course on artificial intelligence, that's lawyers' continuing education, and I have researched it extensively. And I, as well as my firm, are going to be given instructions in course and have safeguards put in place by my attorneys to ensure nothing like this will ever happen again, and I couldn't more deeply apologize to the court. Thank you, Mr. Schwartz. I realize this is a difficult moment for you, and it's easy for something to slip someone's mind, but I noticed that among the people you apologized to, one name was missing, and that's Roberto Mata, your client. I was remiss. I do apologize to my client. Let me ask you, did you tell your client what happened here? I did. When? More than once, most recently 2 days ago. Did you reach out to him, or did he reach out to you? I reached out to him. Thank you. Your Honor, could we just ask a brief question to Mr. Schwartz? This is one of the representing attorneys, the respondent's attorneys. Make attorneys get attorneys. Just to clarify one thing, of course, go right ahead. Mr. Schwartz, I just wanted to go back to your use of the firm's Fastcase subscription for a moment. You said that you used Fastcase in the first instance to try and research in this case. Yes. Did you run into any limitations with Fastcase when you were doing that? Yes. And what were those limitations? Fastcase did not have access to federal case law on this issue, or on any federal cases. So you attempted to research in Fastcase and found that you weren't able to access federal cases when you did text searches? That is correct. Thank you, Your Honor. One more thing, Your Honor, from another attorney, Ms. Foti. Mr. Loduca, in connection with the letter to the court seeking adjournment for a vacation, do you recall reading that letter? Yes. Do you recall noticing that the letter you referred to the undersigned as being on vacation, or do you believe you were representing that another individual was going to be on vacation? My intent of the letter was because Mr. Schwartz was away, but I was aware of what was in the letter when I signed it. Did you intend to mislead the court? No, I just attempted to get Mr. Schwartz the additional time he needed because he was out of the office at the time. Thank you. The court. Does the law firm representative wish to say anything? I don't have any questions. Mr. Corvino. Yes, Your Honor. My name is Thomas Corvino. I'm the sole equity partner for the firm. A little background. We are a four-attorney firm practicing in New York City, primarily before the courts of the state of New York and the New York State Workers' Compensation Board. We do not regularly litigate in federal court. Neither myself nor the firm have ever been sanctioned before by any court or tribunal, disciplined or sanctioned in any way. On behalf of the firm, I want to apologize to everyone involved with this, the court, our client, our adversaries. We deeply regret what's occurred. It was never our intention to deceive the court. We have gone over for some time now what Mr. Schwartz's mindset was, which led to all of this. I have worked with Mr. Schwartz for in excess of 30 years. He's at all times been diligent. He has done fine legal research. His legal writing skills I thought were excellent. The firm had no reason to believe that he wasn't capable of representing the client's interests in this matter or doing the support work to continue to represent the client's interests in this court once the case was removed to this court. With respect to the firm's resources for research, since we practice primarily in state court, fast case has been perfectly sufficient for our needs, and has been, and it was preceded by the entity described earlier as lowest law, but we never experienced any shortcomings with it. Originally, it contained both state and federal access in addition to other services that we paid for. I was under the impression we still had state and federal access, but became aware of it only at the point the court issued the order to show cause. When we did our research with Fastcase and contacted them, it appears there was a billing error some years ago where they stopped billing the firm for certain services but continued to bill us for others. So I was paying invoices for Fastcase, believing it to be fully in effect. What they actually had done was limit our access to federal case law, or to state law only, while allowing us to still have access to state and other services we had paid for. With respect to remedial measures being taken by the firm, as we just stated, all the attorneys are aware that we have access to both state and federal, and that all other resources they need to effectively represent our clients. It's the matter on which I have always seeked to run the firm and represent our clients. We retain ethics counsel for both these matters and to provide CLEs on the issues of research and how artificial intelligence is affecting the landscape. Likewise, there will be mandatory training for the attorneys with respect to notarization, something that these clerical errors should not occur. I accept a level of responsibility of not having gotten involved in a more hands-on manner when the research was being done, but the manner in which I've run the firm historically is that the attorneys conduct their own research, work on their own files, and again, we have 30 years of more than competent practice by Stephen, and I have worked with Peter for 26 plus years. Led me to be comfortable that they are capable of conducting the research, preparing their briefs, and completely and effectively representing our clients. I can, again, express my remorse, and I know my attorneys feel the same way. Again, it's obvious the reputational damage that's being sustained by the firm already to this point because of how newsworthy this issue is. I assure you that and all of what's taken place will ensure that we will put remedial measures in place and this won't happen again. So then the court gives Mr. Bonino from Avianca a chance. This is the defendant, and they're the ones who want the thing dismissed. Your Honor, we don't have the difficult job you do to determine the sanctions for what happened with regard to this motion, but like you, just to revert it to the clients who are involved here, Avianca's position is still that this case should be dismissed on the merits. Plaintiff's counsel has known for more than a year that they have a time-barred problem, and in that year they have not been able to come up with a credible opposition or case law in effect. I think Mr. Schwartz admitted that he wasn't able to come up with any cases in opposition to our motion. We request that our motion be granted to dismiss. So then the judge gives Ms. Foti another chance to conclude. I don't want to minimize the conduct here, she says. Clearly, my client should have taken more care and should have had more conversations with Mr. Schwartz, but I think it's crucial for the court to focus on my client's intent. His intent was to do what he believed was the right thing, and he was helping Mr. Schwartz. He was asked to appear in this case on behalf of the firm. He was helping Mr. Schwartz appear on behalf of his client, and he relied on Mr. Schwartz. They've been working together for 27 years. He had no reason to doubt that Mr. Schwartz was doing the research appropriately. The only time he even became aware that there was an issue in the actual research was when Your Honor issued the order to show cause. I understand that the order asking for copies of the cases is something that may have raised an issue or should have raised an issue. Why can't he get the cases? But it did not. He did not think that there was a chance that these were fake cases. He thought I think that's what is crucial to think about here. We can't look in hindsight of what was happening and then say, oh, you should have known at the time that there was an issue, when that is not even something in my client's mind at all. All he could think of is, maybe there is an issue about getting these cases. I'm going to turn it over to Mr. Schwartz, who is a reliable and really experienced attorney. I have no reason to doubt that he is going to do what the court asked him to do. And then he produces a pile of cases. I understand these were portions of cases, but still it did not occur to my client that these were fake cases. They could be whatever reasons that there could be whatever reasons that these cases were not produced completely based on the resources the firm had. But under Rule 11 and under Section 1927 about frivolous filings, and in your inherent powers, I suggest that the case law is very clear that if the court is to sanction him, there has to be a finding that he acted in bad faith. But he did not act in bad faith. I think it's clear from the submissions and his testimony that he was attempting to take responsibility and do what he needed to do, and he had no reason at all to doubt that what was being presented to the court were legitimate cases. I would suggest, Your Honor, that this is not a foundation in order to find Mr. LaDuca should be sanctioned. Thank you. Oh, she goes on to cite a case in which an associate signed an affidavit that contained misrepresentations. The associate relied on other colleagues, and it was clear that the associate believed that what he was presenting to the court was accurate. And the associate said that he was entitled to rely on that information provided by colleagues, and the court found that he should not be sanctioned. I would suggest that this is the same here. My client was allowed to rely on his colleague, and he did so, and he did not act in bad faith. And this is a terrible situation. He takes full responsibility, etc. And then there's a little bit of a mix-up here with the judge where one of the other attorneys wants to speak but didn't ask to speak, and the judge wants them to make a formal request, so we're just going to skip that. Your Honor, says Mr. Minkoff, our clients understand that we as their lawyers understand that this court's reaction to the filing of the brief that had a false case in it, false case law that was obtained from ChatGPT, there is no question that should never have happened, and our clients are mortified and apologetic that it did. But the fact is, as Ms. Foti pointed out, there was no intentional misconduct here. This was the result of ignorance and carelessness. It was not intentional, and it was certainly not subjective bad faith. Now, as I said, Mr. Malsby will delve into the evidence a little more deeply, but I wanted to talk about the significance of this case. And the fact that this case is significant is indicated by the amount of press attention, fourth wall moment, the amount of people here in the courtroom today, the amount of articles, the amount of buzz online. And the reason for that, at least as far as the legal profession goes, is that this case is schadenfreude for any lawyer. There, but for the grace of God, go I. And the reason is that lawyers have historically had a hard time with technology, especially new technology. And this was very new technology. Lawyers are usually about 10 years behind technology. And we have lived in the course, certainly of my 40-year career, through lots of new technology coming along that lawyers have to learn to use. Sometimes their firms require them to use it and they have to figure it out for themselves. Doesn't always work the way it should. We saw that way back when Westlaw and Lexis were competing with each other for the marketplace, and both of them were purporting to be the source, and it turned out that neither of them had all the cases, and you had to look in both sources. It's not getting any easier because then at least there were just two sources of research, mainly Westlaw, Lexis, and the books, 3 sources. Now there are many online sources, Fastcase, Justia, a number of other online sources lawyers use, and we navigate that. Predictive coding is another example of a technology that came along. It was supposed to solve all the discovery problems, and we all learned that it didn't work that way. But again, at the beginning, there were a couple of vendors who did it, a couple of programs. Now there are literally hundreds of AI programs. There are hundreds of AI, maybe thousands of AI vendors that law firms use. Some know what they are doing, some don't, and the lawyers have to figure it out. And there aren't too many lawyers that practice in this court that have not been burned in that context. So what happened here is, in our view, another iteration of that same problem. Not a new problem. The State Bar Association has been well aware of this, created a committee on the law and technology about 5 or 6 years ago precisely to try and teach because they knew that lawyers weren't learning this stuff and weren't good at doing that kind of job. And the Bar Association dedicated itself to trying to teach lawyers and trying to keep up with the tech changes. But the fact is that there is no bar association, no law firm, no lawyer who could have known all there was to know about ChatGPT and its foibles 3 months after it came out. It came out in November, I think November 22nd of 2022, and Mr. Schwartz was using it 3 months later. That was the problem here. Mr. Schwartz, someone who rarely does federal research, found himself in a pinch, chose to work with this brand new technology. As he said, he thought he was dealing with a standard search engine, and it wasn't. He was playing with live ammo. He was playing with something, a generative technology that didn't have access to the database that he thought it did. And it didn't have access to actual case law and was fully capable of making up the case law, which is what it did. He had no idea about the risks or dangers until it was too late, and he didn't know because the technology lied to him. He asked it for cases, it gave him cases, it just made them up. It is obvious in hindsight, after the examination that this court has done, that those cases weren't real. But at the time, trying to put something together and dealing with citations that seemed supportive, it was not immediately obvious at all. And certainly there were no disclaimers saying that this would happen or this was likely to happen. And when he challenged it, went back to it and said and tested it, it doubled down. It kept lying to him. These dangers were not generally known about back in March or April. And one of the reasons that they are now generally more known is because of what Your Honor has done. Your Honor made this order, and the world now knows about the dangers of ChatGPT. Should this court be outraged that lawyers submitted false cases to it? Absolutely. And because the fact that there is a program out there that's available to lawyers that literally makes up cases is in fact outrageous. Should the court be upset at my clients for their ignorance and carelessness? Yes, absolutely they should. And the way they handled it after the problems were discovered, they were careless. But they should not be sanctioned. We submit that the answer for that is no, they shouldn't be sanctioned. They made a careless but honest mistake. They thought that they were using a search engine, and they weren't using a search engine. As it turns out, they should have reacted more quickly, but they did not act with subjective bad faith or malicious intent. Now, this court has done its job of warning the public about these risks, warning the profession about these risks. The court breaks in, but that's not my job, and I didn't set out to do that. Mr. Minkoff replies, I understand it's not your job as a judge to do it, but you did do it. The court says, this was not intended as a warning. That was intended as an order to show cause to bring these respondents before the court to answer for their actions and nothing more. I understand that, Your Honor, but whether Your Honor intended it or not, the effect is what I said, which is that the public is now on notice of this problem, which my client was not on notice of and did not know about at the time. Now, just as AI teaches itself, now it is up to the lawyers to learn about these dangers. Thank you, Mr. Minkoff. Thank you, Your Honor. Mr. Malsby steps up. I'd like to pick up where Mr. Minkoff and Ms. Foti left off. We all strongly believe that the appropriate standard here is subjective bad faith. We believe that the law is clear, that subjective bad faith is required to find against these in this situation. I think you had heard plenty today. We all agree that they made a mistake. He should not have used ChatGPT, but this was not a situation where he was willfully ignoring something. I'm going to skip a little bit because I think we're starting to repeat a little bit, and that wears on me. I don't like it when we repeat. Your Honor elicited testimony, yeah, and they talk about cases. Weddington was a case Your Honor dealt with. Lawyer had a document in his hand. There were emails in the firm. It said the client was domiciled in New York, and they said the exact opposite thing on the piece of paper. The difference here, even with the backward looking, the practice should have been better. The respondent should have picked up on the warning signs fine. The difference is, unlike those other cases, our clients had a countervailing fact. They had something telling them this is a case. This is a real case. He continues to argue that Mr. Schwartz didn't know how ChatGPT worked. I think we can safely start skipping ahead. So they are partners in the same firm, and they've supplemented each other's arguments, and he's going to continue. Okay. Warnings have been bolstered, and the question is, will sanctions send a deterrent message? And the argument from the defense is that the three lawyers, the two that are being sanctioned plus the firm, have been totally and utterly humiliated. So why punish them any further? The court says, I think the point has been made, and the court doesn't want to hear any more. I heard from the principal of firm, is this something that's in the record that you are going to tell me, or is this something not in the record? He says, I'm summing the record. Okay. So I think we're pretty good here. Given the remedial measures, given the fact the firm has done to the lawyers, etc. And then the court concludes. Okay, here's where we'll finish. A few closing comments from the judge. First of all, I want to thank Mr. Minkoff and Mr. Malsby and Ms. Fody for their very fine presentations. I want to thank Avianca's counsel for being present, and I want to thank Mr. Corvino, Mr. LaDuca, and Mr. Schwartz for their presence here this afternoon. I'll be taking this under advisement and issuing a written decision. I want to make an important observation. It's not fair to pick apart people's words, but I'll just note that, repeatedly, this has been described as a mistake. And framing this as a mistake, I understand why it's framed that way, and the mistake is to have submitted the brief on March 1st that cited non-existent cases. But that's not what this is all about. That's part of what this is all about. This is the beginning of the narrative, not the end, not what was in everybody's mind at the time they drafted the brief and uploaded it to the electronic case filing system. I doubt we would be here today if the narrative ended there. There was a reply brief filed by Avianca. The record will reflect whether that brief put Mr. Schwartz and Mr. LaDuca on actual notice that their cases were non-existent. There was an order from the court on April 11th calling upon Mr. LaDuca, not a law firm, not an entity, not the plaintiff, but Mr. LaDuca to submit copies of the cases. We know how Mr. LaDuca responded to that. We know how Mr. Schwartz prepared the response. We know what they submitted and what they said about it. We know a lot more now, but this case is not just about the March 1st submission, it's about what happened after. It's an important aspect and an essential part of the narrative. So I thank everyone for being here and participating and taking the matter, and I'm taking the matter under advisement. And he marks an exhibit and adjourns. And that was the hearing. And I agree that there was more going on than just an accidental submission of fake cases made up by ChatGPT. That the judge needed to find out what more was going on, and now the judge has found that there was a little more going on, a little bit of negligence, a little bit of carelessness, a little bit of, you get good at doing your job after 25, 30 years of practice, and yeah, I'm sure they were like, oh yeah, sure, this is fine, just, send it off, we'll be great, because everything else has been great for 30 years. So they didn't have their guard up when you need to have your guard up. In my firm, I have a professional policy that I check anything that I do 3 times. If I'm transferring money or if I'm sending an important email to opposing counsel or something, I force myself to literally read everything 3 times, and sometimes more if I'm like producing something and going through the editing and proofreading process. But if I'm finished with something, I'm going to do a funds transfer or something, I literally go through all the motions of checking it 1, 2, 3 complete times to make sure. And sometimes I'll do it backwards. I'll do like, the first one will be top down, the second will be bottom up, the third one I'll use like find and replace or something. But I do multiple checks to make sure that I'm actually proofreading and actually checking the numbers, that my account numbers haven't gotten changed by some hacker or something like that, and I'm sending money to a different place. There are all sorts of pitfalls and risks for lawyers representing clients. So the fact that they didn't catch this one is kind of surprising because they had all these opportunities. But the fact that Mr. Schwartz got there in the first place by thinking ChatGPT was more than it was, that's sort of understandable folly, a bit of schadenfreude. But to me, the sanctionable conduct was the reaction to that, the follow-up to that. And I can announce the judge did issue his sanctions ruling today. He issued a $5,000 fine to the respondents for their carelessness, required all of this to be sent to the affected parties. So Mr. Roberto Mata, the plaintiff, he gets a copy of this. Also, all the judges. Any of the judges that were cited in these fake cases, if the judge is a real judge, they get that. This whole thing gets sent to them too, and the respondents have to certify that they've sent these things to the client and to the affected judges and things. Other than that, the judge admonishes the responding parties, the offending parties, but that's it. That's it. A $5,000 fine and worldwide humiliation for the firm, unfortunately, and then notification to all the affected people and entities. And that's it. So I think enough damage has been done there. The $5,000 fine is probably has nothing to do with ChatGPT and has more to do with the sort of negligence or carelessness in handling things after they should have known that there was a problem. So don't use ChatGPT to do your legal research for you. And of course, you saw be careful how you phrase your prompts when you do prompts, because the way Attorney Schwartz phrased his ChatGPT prompts affected whether it generated cases or cited cases. And it doesn't work that way. So don't think you can just go do that either. But instead of giving it like a neutral, objective response, it wanted to fulfill his request, so it generated or hallucinated cases, a couple of them together into one case or something, so that it looked like there was something supporting it. If I asked ChatGPT, write me a story where a small child rolls down a hill, as you wish, ChatGPT is going to try to write that story and not tell me, oh, well, you shouldn't, the law says you can't roll down hills, because no, it doesn't know that I'm asking about the law. It's just going to write a story about a child rolling down a hill. So it just wrote a story about a case that supported his case law. Didn't think, I'm talking to an attorney and I need to cite real case law, and do I have access to real case law? Because it's not a thinking engine like that. It instead hallucinates and tries to fill in the blanks so things look like other things. So don't use ChatGPT that way. Can you, as a lawyer, use ChatGPT for beneficial things? Yes, absolutely. There are lots of awesome use cases for things like ChatGPT. I'm looking forward to Microsoft Copilot eventually when I get access to it. Um, I'm even trying offline private GPT or ChatGPT, the GPT-J Groovy, whatever, on my own system, and trying it on public documents that I'm supplying it to see if I can get it to summarize court cases and documents. My dream would be to give it all the discovery in a case and then ask it questions about the discovery and have it be able to actually point those things out. But we're not there yet, and you can't do that. Well, I shouldn't say you can't do it yet. There might be somebody out there who's figured it out, but it's not a widely known how to do this thing yet thing. Eventually, we'll be there, and it will change the industry. It's already changing the industry, but I can understand a lawyer, especially someone from before these recent internet times, thinking that somebody had developed something more powerful. So I do feel for Mr. Schwartz. I'm actually not that sympathetic towards Mr. LaDuca. You really shouldn't be rubber stamping another attorney's filings, no matter how much you like them or trust them. You really should proofread it. Maybe if you trust them and you like them, you don't have to do the whole take ownership of the case thing. But when you're the appearance attorney, when you're the attorney of record, you are the person whose butt is on the line. So I don't have a lot of sympathy for Mr. LaDuca. I feel more for Mr. Schwartz for being conned by ChatGPT, even though he maybe should have known better in the beginning, but definitely should have known better once he had notice. But Mr. LaDuca should not have been rubber stamping things. So anyway, and some of you I can see disagree with me there and think neither of them should be touching any of these technologies. I'm sure there's still great lawyers. I really, if you can get through 30 years of practice without any sanctions or misconduct, like where that anybody notices your misconduct, no misconduct that anybody notices. Poor phrasing, take that back. That's a remarkable thing. Like I tell people that I've made it 12 years with no misconduct on my part. So that's a big deal. That's a really big deal, and it's also the way that us attorneys sort of police ourselves, is to keep our records clean. Anyway, that's my show. We've been going for an hour and 13 minutes. I love you all. This is a supported channel. This is a community supported channel. I don't take commercial advertisements from VPNs or wallets. So if you would consider supporting me on patreon.com/ljfrench, or through YouTube membership or Floatplane subscriptions or Twitch subscriptions. What else do we do these days? Cash App. Thank you very much in the month of June to Eevi, Ugly Grill, Torpedan, PureMagma, Eric Tams, TechTechPotato, Gutbrodj, King Aries, The Blood-Soaked Survivors, Kyle Siefring, and please do not credit this account. I love you all. I'll see you in the videos that drop. The next video will probably be the judge's decision in this case, so we'll get to hear what the judge now has to say and how the judge, Judge Castel, reacts to all of this in his opinion. Love you all. Have a good one.